So the day that this episode is going to be released on January 9th is a very special day in the calendar. Imagine picture Rune in 1431. That's the day that Joan of Arc was put to trial in England for by the English for heresy.
Guessing you're not using what Shakespeare has said about her with her words. It sounds like you have a different source.
Well, I'm here from the French perspective. I'm sure that
I see.
The British were not thrilled about her. They called her witch. They made up a lot of crimes to prosecute her under. Made up, right?
Well, she was later exonerated, right? Or they came back some years later.
Well, there's sainthood or whatever. But yeah. Just saying, Henry VI Part 1, she's a witch. But, we can go with what you're saying, Tahmineh.
Well, here I am representing the French side of the story, so take it or leave it.
Two crazy cases of qualified immunity this week here on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We are recording this on Thursday, December 11th, 2025. Now, you are listening to this episode in 2026. I believe we're releasing this on January 9th, and that's because, believe it or not, here at the Institute for Justice, we do not work with Old Scrooge. He is not in the building. I've never seen him in any of our offices. And so we actually do take a little bit of time at the holidays to spend times with our families or whatever. Some of my colleagues do, when in their time off. And so we are not going to be producing shows during the holidays. So we're doing a few extras ahead of time. But I hope you still enjoy this episode because the two cases we're going to be talking about, both of which involve qualified immunity, are still both sadly very relevant in 2026. One is from the Sixth Circuit and one is from the Eighth Circuit. So we'll get to those in a little bit. Now, the first one from the Sixth Circuit will be brought to all of you by Tahmineh Dehbozorgi, whose name I thought I'd get right, and I think I just butchered. She will be first up in a little while, and she has something special for you all as well. But first, I'm going to introduce who's going to do our second case from the Eighth Circuit, and that is a first-timer here on Short Circuit. That is Benjamin Marsh. So Benjamin recently joined us here at IJ, and very unusually, in my experience, he lives in the DC area, and he works at our headquarters in Arlington, Virginia. And he's actually from there and has lived most of his life there. So if you're in my line of work, or you're in politics, or all the things connected to the beast that is the federal government, and you go to DC, most people in that quote industry are not really from DC. So if you go to Hollywood and you run into Hollywood people, hardly any of those people are from Hollywood, or maybe LA in general, but most people, right, they're from North Dakota or wherever, and they went there to make their fortune. They caught the midnight train. They're still believing. Well, you kind of have the same thing in DC. So, Ben, I want to hear from you on your reflections on actually being from this area, and then, what are these other people you work with like when they find out, oh, you're actually from here?
Yeah. Well, thanks so much, Anthony. It's great to be here. It's great to be part of IJ. It's an interesting thing being a DC native, born and raised. I hope well. It's interesting. I was born at a hospital that no longer exists, which is Columbia Women's Hospital. It used to be in Foggy Bottom. I think it's condos now. But it's an interesting thing. DC is one of those cities, right, where you go out, you meet people, you're doing your network, what have you, just bumping into somebody at the coffee shop, and you just say, oh, hi, I'm so and so, I'm Ben. And almost invariably, the follow-up question is, oh, where are you from? right? And even I do this, which is sort of, I mean, and that maybe that makes sense because my experience has been that most people aren't from DC. And so it's sort of a rare thing for me to then say, oh, I'm from here. And then people will kind of look at me for a second and say, what, here? Where here? I say, no, from here, from DC. Like I was like, you moved here? You've been here? No, I was born here. Oh, okay. So, you know, it is sort of a strange and interesting thing. I love being from here. You know, certainly as an attorney, it's where like a lot of the action happens. You know, I think that it's the case that DC has the most lawyers per capita of any city in the country. Is that wrong? I think
No,
that's
it's
right.
just bad.
I think that's right. Well, yeah, you know,
It's right, but it's bad.
I'll try to reserve.
They still
judgment.
don't have the bar exam to get the DC bar though, so that's good.
Yeah. That is good. So, but it's been great. You know, when I was a kid, I was born here. I lived here for like a year. We bounced around a little bit, Norfolk, Virginia, Ann Arbor, Michigan. But then always back home to DC, and you know, it's been a really cool city to grow up in. You know, I think it's certainly different, and I will mention this too. Like, it is sometimes shocking to me, just in talking to like family or people, you know, like when I'm out traveling, and so many people don't realize, like, the DC is a normal place, a normal city. They're just normal people that live here. Not everyone that lives here works in politics or is a lobbyist or works for the government in some fashion. But it really is just a normal city with, you know, regular old people and regular families trying to make their way through the world. So
I'm curious of you know, all of us lose touch to a large degree with, you know, who we went to high school with or whatever. But from what you know of folks you went to school with before college, did most of them just stick around and live normal lives, or is there kind of an impetus maybe to leave the area because it's, you know, everyone else is coming, or do you get a sense of that?
Yeah, so I went to a very small school here in DC called St. Anselm's Abbey School, and I think I was one of 36 in my graduating class, and
That is pretty small.
Yeah, it's pretty small, and for most of us, really, you know, we had been together from sixth grade, from when we were 10 years old, all the way through the end of high school, and I don't know that any of us were really normal, or just sort of like the average person from DC. Everyone's a little quirky there, but you know, it's been sort of a mix. I think in part it was just life took people in interesting places and interesting directions, but so it was a very small, close-knit group, and I didn't know anyone that had the, you know, like the burning itch to like, I have to get out of here. I can't stand it anymore. Like, please, God, take me away. But yeah, you know, I certainly had friends and classmates that went on and moved around, some of whom have found their way back. You know, I think we were certainly all very grateful for the unique experience of growing up in the middle of everything that DC has.
Right. For better or for worse?
Yeah, for better or for worse.
We might
Exactly.
add. Now, for better or for worse, Tahmineh is about to discuss this qualified immunity case, but she also has a little story about someone who left her hometown with her sights on bigger things.
Absolutely. So the day that this episode is going to be released on January 9th is a very special day in the calendar. Imagine picture Rune in 1431. That's the day that Joan of Arc was put to trial in England by the English for heresy. The teenage Joan of Arc stands in a courtroom that's dressed up to search for the truth, but everyone in the room already knows the outcome they want. The judge asks her a question designed to trap her. Are you in God's grace? And if she says yes, well, she's being presumptuous, even heretical. And if she says no, she's admitting that she's abandoned the principles of her faith, and that is also heretical. And that is our theme today, that what are these legal trap questions that force a party to lose, no matter how they answer the question? So her answer was, if I'm not, may God put me there. If I am, may God keep me there. But that did not work for her, because nonetheless the court moved forward and still burnt her at a stake for heresy.
I'm guessing you're not using what Shakespeare has said about her with her words. It sounds like you have a different source.
Well, I'm here from the French perspective. I'm sure that
I see.
The British were not thrilled about her. They called her witch. They made up a lot of crimes to prosecute her under. Made up, right?
Well, she was later exonerated, right? Or they came back some years later.
Well, there's sainthood or whatever, but
Yeah.
Just saying, Henry VI Part 1, she's a witch, but we can go with what you're saying, Tahmineh.
Well, here I am representing the French side of the story, so take it or leave it.
We'll go with it.
Absolutely. So how does that relate to what we're discussing today? Because in modern civil rights litigation these days, there's a trap question, especially when we're talking about qualified immunity. Obviously, the first prong of the qualified immunity test is whether constitutional right was violated. And another prong of this, which our cases will discuss that in detail, is was the right clearly established? And the case that I'm going to discuss, Guptill versus City of Chattanooga, Tennessee, which is a Sixth Circuit case published in November 26th of 2025, gets into a very deep discussion of whether a right is clearly established, and the court discusses that, well, maybe or maybe not, but the way that the parties framed it is not necessarily how we want to hear it, so the party nonetheless loses. So I think this is a trap part of qualified immunity, that you go in front of a court with real injury that was caused by a police officer or a government official, but the court just does not accept your framing of your argument as a clearly established law. So what were the facts of this case? They're very interesting. This is not your regular qualified immunity case where a cop is trying to arrest someone and they beat the guy up or something like that. Miles Guptill checked himself into the hospital because he was experiencing hallucinations. He had a history of mental illness. So he goes to the hospital and is like, I'm not feeling well, please give me some medication to calm me down. And while he was in that situation, the nurses and the hospital staff were trying to administer something called a Godin shot, which is a tranquilizer. And around the same time, the doctor completed this paperwork called the Certificate of Need, which is a Tennessee mechanism that permits emergency detention in certain mental health scenarios. But the doctor did not actually sign this paper till later when chain of events had already happened. So that becomes significant later on. So around 1 p.m. when the hospital staff wanted to administer the shot, Guptill repeatedly asked them, why are they doing it, why he needed it. And he didn't really raise his voice. He was being calm, just not really receptive of the shot. But, several nurses and doctors tried to, calm him down and restrain him and tell him, we need to give you this, you need it. And he kept saying that, I don't want to get this shot. And as the staff became more and more insistent, they began physically getting more involved, and several male nurses even got involved to keep his head down. In the meantime, this police officer, Officer Gunn, he was a police officer at the local police officer that was moonlighting as hospital security guard, but he was wearing his badge. He comes in and tries to help the nurses to restrain Mr. Guptill. And while he intervened, he twists his arm behind his back, and when the plaintiff, Guptill, tried to pull away, the police officer punches his head into the cinder blocks wall and caused head trauma. And there are a lot of back and forth between the nurses and the police officer. The nurses did not like what the cop did. They're like, well, we were handling it, we were in control, why did you get involved? But then the police officer said that I believe that you guys did not have a handle on it, he was resisting you, so that's why I got involved. So what it comes down to is that the medical staff absolutely did not ask this police officer to get involved. So the court already accepted that fact as being accurate, that the police officer intervened on his own. And then later on, our plaintiff brings 1983 case against the city and the police officer for excessive force, and he also pursued several state tort causes of action against him. But what happened is that, well, as usually happens in these cases, that the court gave qualified immunity to the police officer on the excessive force claim, the federal one, and also granted city's summary judgment across the board on all the claims. But the court still kept a Tennessee common law assault and battery claim against the police officer alive, finding a genuine dispute on whether the force was in fact excessive.
Right, and then that claim was basically remanded, or not remanded, allowed. It would go forward in state court because there were no federal claims left. But at least he could pursue that in state court, perhaps.
Yes. But that claim is not really like the issue in front of the Sixth Circuit. So we mostly will be focusing on the qualified immunity aspect on appeal. So it's interesting. Why is this different? Because we're not facing like a regular excessive force claim. The way the court tried to frame this is an excessive force claim in a context of a medical emergency and not just like any other regular instances where we see all the time. So finding a case law, the court found to be a little more difficult. So when going to the analysis of the qualified immunity, prong one, when we say prong one and prong two, these things do not have to be in order. So, but for the sake of the organization of the case law, the court first analyzed, whether there was a constitutional violation. Well, they were not really excited about the fact that the cop punched our plaintiff in the head, and the court said that the record supports both parties' perception but it wasn't objectively unreasonable for the police officer to perceive a medical emergency given the plaintiff's repeated delusions and the hospital's emergency detention posture. Like the court said that, well, the doctor was filing that paperwork for a medical emergency. And then the question was like whether the force was necessary, and even viewing facts in the plaintiff's favor, the court held that no reasonable jury could find it objectively unreasonable for the police officer to believe some force was necessary to assist the medical staff in restraining Mr. Guptill for medication. And what about the degree of force? Honestly, I'm always confused like how the courts would actually measure this. They got into the details about, well, our plaintiff was smaller in size compared to the police officer. There were so many other nurses around him. There's no way that he would have posed an actual danger physically to anyone. But still, like, there was a genuine dispute of whether the degree of force punching his head into the wall was more than reasonably necessary. So if you're listening as a civil rights lawyer, you perk up here. So the court is basically saying that a jury could find this excessive. But not yet. When the court goes to the prong two, the trap question, whether the right is clearly established, the court says that, okay, even if Guptill can show that a constitutional violation happened, the claim still falters on whether the right was clearly established. The court frames the right issue as something like whether a person in a mental health emergency who is physically resisting treatment in a non-threatening manner has a clearly established right not to be punched by a police officer. Just let that sink in for a second. And I mean, look, the plaintiff tried to frame it more generally, saying that, I have a right to be free from an unjustified punch to my head by a police officer. But the panel kept emphasizing that, well, you need to find a sufficiently analogous precedent in a situation like that, and notes that the plaintiff leaned on some unpublished state court opinions that we don't really treat it as clearly established, and then goes into this whole analysis that there are single punch cases that do not squarely fall factually within the same scenarios here. So the bottom line is no binding case law clearly established that an officer in these circumstances could not use a single punch to force compliance when patient pulls away. So the police officer gets qualified immunity. And this is where the Joan of Arc story comes in, is that clearly established and qualified immunity contest can clearly just be a judicial trap. So when, I hear it from law professors and legal scholars, like, well, you cannot, in fact, get around qualified immunity if you can show clearly established. But is it really? We see in a situation like this that it's not necessarily clean cut. Even if parties show some cases, the court could just completely dismiss those things and be like, I don't frame the issue this way. And they can either make the right too specific, so you'll never find a case law that is in fact on point, or make it too general. So the court will say, well, you define it too high level and it's just in an abstraction, so you can't really prevail on that. So I think the issue becomes that, well, the courts need to thread the needle, and I don't think they really give the plaintiffs in situations like this to have an opportunity to do that. So Judge Topar has a very interesting concurrence on the matter, and I think it's I kind of like the point that he raised, is that, Supreme Court has never said anything on the fact that what precedent, even on its own precedent, count as controlling authority for qualified immunity. So if the Supreme Court isn't sure what precedents we can rely on to show the clearly established prong of the qualified immunity, how can a police officer do that? How can we say that a police officer in this circuit, should have known that other instances like this happen? So the right is clearly established when the Supreme Court itself hasn't really defined the boundaries of that. So should the police officer look at only Sixth Circuit cases? Should the police officer look at only the state cases or the Supreme Court precedent? Should the courts give weight to all of these equally, or do some precedent are more clearly established than the others? So it's unclear. And Judge Topar also pushes back on the idea that officers should have to prove over not just the circuit precedent, but also other circuit cases from other jurisdictions, including, for example, I see in some instances the 11th Circuit might come into place. So Judge Topar really finds that problematic, that what about sister circuits that might have had some similar facts? Should the court rely on that? Should the officers bring these as to their briefing? So
isn't he kind of, if you take that to its logical conclusion, implying that you can never defeat qualified immunity?
That's kind of
by narrowing the universe of just Supreme Court. Now, I don't think he actually believes this, but that's kind of the cryptic lesson I'm learning from his short concurrence.
Yeah, I agree with you. I think he's just, generally he sounds like he thinks that, the cops should still prevail on this issue. But at the end of the day, it's very all over the place. What actually constitutes the case law that parties should rely on, or the court should rely on for qualified immunity. So I think Judge Topar is also agreeing that maybe this is a trap question. Maybe this is a trap question for the law enforcement, that can a circuit court go and find another on-point case from a different circuit and be like, the right is clearly established. Here's another case that happened in the 8th Circuit, and you, police officer in Tennessee, should have known about this, and let the parties prevail. So I think Judge Topar is worried about that part more than the fact that the plaintiffs cannot show it. But he doesn't really come down either way. But I think his concurrence on this matter is very interesting, that he points out to the absurdity of the fact, and the fact that the Supreme Court has not really defined the universe of clearly established.
Ben, do you think it's all a trap?
It's hard to say no. I don't know that it's an intentional trap, right? But it certainly seems that is the effect that it has, And it's hard to set it aside, but the facts of this case are just outrageous, as Tahmineh mentioned. The idea that you're asserting a right to not be punched in the face, or to not be punched into a cinder block wall. I hope I have that right, is kind of absurd just on its face. But I did think that Judge Thapar's concurrence was really interesting as well, and it does give me cause to wonder, where, for whom, right? Is it important? Whether there's Supreme Court precedent, there's internal circuit precedent, there's other circuit precedent. And I think maybe part of this, and maybe we can get into this a little bit later too, but is the sort of what I see as the harm that Pearson did, that Pearson v. Callahan did, in sort of undoing the prior sort of Saucier procedure, right? The Saucier v. Katz case, which sort of required courts, right, to like do the two-step to make the analysis and the determination of whether a constitutional right had been violated, and then say whether or not it was clearly established. I think that this is sort of part of it. So maybe we could resolve this trap a little bit. And I'm wondering, certainly what Tahmineh, what you think about this by saying like, okay, if it's not from the Supreme Court, if it's not internal, clearly established precedent for our circuit, maybe we as a court, take that as incumbent upon us to then consider, whether it's appropriate to look to case law from other circuits to then say like, well, they said that this, might have been clearly established. It was clearly established there. Maybe we should take that as an opportunity to say it ourselves now, right? But that's where the trap, I think in large part comes in, is that they just never get to that part, right? They never get to that step where, we'll say this wasn't clearly established up to now. Let's go ahead and make it so, right? So they don't have to do that, and then just round and round we go, which I think that's...
And to the court's credit, they at least do that here, even though it, so I guess the next guy punched into cinder blocks who's checked himself into a hospital but doesn't want to take a shot will be safe. Of course, the cop won't have read that case anyway, but that's another story.
Right.
Yeah, this is an unusual case, as Tahmineh says, because it is an unusual set of facts. But then, of course, that is the flip side of qualified immunity, is there's less likely to be a case about it. And so the only way to win, if a court is going to take really seriously this on-point precedent, which we always talk about with qualified immunity and doom so many cases, because you can't find that exact match, and so qualified immunity, even if it was really bad. What the court doesn't get into here is the whole obviousness exception, which Taylor versus Rojas a couple years ago kind of revitalized. They don't even ask that, and I don't know if perhaps it's a failure of briefing, perhaps the court just didn't care about that. Tahmineh, do you get a sense of should the court have asked the obviousness question, or was it kind of baked in anyway?
I think the court was trying to resolve this on like the narrowest matter possible, nonetheless, without getting to the obviousness. I don't believe that parties briefed the obviousness exception. It doesn't sound like from the opinion that was mentioned. But I mean, I think you can argue that. Well, yeah, I mean. Punching a guy in the head like that is obviously that should show the court that there's like a genuine dispute of material fact, whether it was excessive. So maybe the government shouldn't have at least prevailed on summary judgment, let the parties to go in front of a jury and let the jury decide that question. But the court was very skeptical of that the trap question of whether it's clearly established, which I think goes back to the incentives issue. I mean, one of the big picture problems with the qualified immunity doctrine is that it creates incentive for the government to violate people's rights in creative ways. And the more creative it gets, it's more likely to actually get away with it, because you obviously cannot point to a similar case and be like, hey, this was clearly established. And I personally find that to be disturbing. And I think this is an example of a very horrific chain of events for everyone involved. And you could argue both sides that maybe the guy was, being unruly, and maybe the police officer actually did perceive something. But at the end of the day, the plaintiff was not able to actually go in front of a jury and be like, hey, this is what happened to me. You guys decide. And I think that's another issue with a case like this.
Well, we'll move to a different kind of case, but still very much about qualified immunity now. And this is from the Eighth Circuit, and it is like we don't have a stats team counting these things, but I swear this is maybe the fourth or fifth case we've had that involves a federal appellate court reviewing qualified immunity about what happened to people at a protest in the aftermath of George Floyd's murder. So this was one of those protests. The police think people are getting out of hand, and someone very unfortunately gets hit in the eye. And so the question is that a violation of that person's constitutional rights? And also, is it clearly established? So, Ben, there's a few interesting things at play going on here, including a First Amendment claim. So set the table for us.
Yeah, absolutely. Like you said, this is another QI, another qualified immunity case coming out of the Eighth Circuit. The Eighth Circuit actually does a pretty good job of sort of relaying all the relevant facts, but for our purposes, I'm also going to sort of dive through a bit of the district court's factual findings and recitation. I think it sort of helps paint a fuller picture here. So we're back in May 2020. 2020 was a famously calm, very chill year. Not a lot going on.
Well, in some ways, there wasn't a lot going on.
Yeah,
until there was.
That's until there was, right? But yeah, so we're here. So this is May 29th, 2020. This is 4 days after George Floyd's death, which was May 25th of that year. And protests were going on all over the place, and Omaha, Nebraska was no different, right? So in the course of sort of the protest here in Omaha, we had protesters out in the streets repeatedly, throwing objects at police officers, attempting to set fires, breaking store windows, et cetera, et cetera. And the Omaha, Nebraska Police Department was somewhat overwhelmed. And they'd called in, some sort of local other law enforcement units to try to come in and help. And as part of that was the Sarpy County SWAT team, who a couple of their members had then become defendants in this case. And they were called in to sort of help with crowd control. And among this SWAT team are two names that we'll get to know, who are Deputy Palmer and his partner Deputy Strickler. So as I mentioned, sort of, at some point these protests turned violent. A number of these streets had become completely unpassable to the general public, and the decision was made that this protest was now declared an unlawful assembly and in need of dispersal. So the Sarpy County SWAT team, who again included Deputies Palmer and Strickler, they arrived at an intersection in downtown Omaha. It had a Walgreens parking lot where a big part of this protest was taking place. And they joined in with what had been sort of established as a police skirmish line to sort of box in, sort of control the movement, the overflow of the crowd of this protest. And there were a few hundred law enforcement officers there. You had the officers in the front lines in their full riot gear, sort of classically think of vests, helmet, batons, shields, all that kind of stuff. And Deputy Palmer was called in as part of, and I never heard this term, but as pepperball support. So Deputy Palmer,
interesting,
pepperball support.
It sounds like they're helping make a curry or something.
It's an interesting term. I don't know how else to describe it, but yeah. So basically, he had a pepperball gun, which if you don't know what that is, I didn't either. But it's basically what it sounds like, right? So it's sort of like a non-lethal weapon, which I actually take it to be somewhat similar to a paintball gun. If you're familiar, how you load paintballs into this big sort of canister at the top, and they just filter through and you shoot them out. Evidently, that's sort of what a pepperball gun is. And as you mentioned, like this is an actual pepper, right? It's not like the same sort of pepper you'd find on your kitchen table at home. It's actually synthetic capsicum, which is the itchy, the irritant, the burning part of pepper, chemical in pepper that's packed into this very tight ball, and they're pretty commonly used for crowd control, and for sort of riot control as a non-lethal sort of munition, right? So. I should also mention, too, that as part of Sarpy County's guidance, and this will become relevant a bit later, in the use of pepperball guns, they're intended to either be used to target specific individuals up to a range of about 30 feet. And then the guidance is that they can be used for crowd control and crowd dispersal up to a range of about 100 feet. So keep that in mind for now. And sort of the basic idea behind crowd dispersal with a pepperball gun is that you would aim at the street in front of a big crowd, or at a nearby wall or a tree or street sign or something like that. And the idea is that the ball would sort of hit that area and then explode, and this the synthetic pepper particulates would expand and bother people and get them to move away, right? So here we are. We have Deputy Palmer and Deputy Strickler as part of this skirmish line at this Walgreens parking lot. And now let's check in with who ends up becoming our plaintiff. It's a guy named Adam Kopp, right? So Adam went to the protest, and this is something that nobody disagreed with, nobody disputed. He went to the protest basically just to observe, right? Just to see what was going on, and to sort of provide assistance to his friend, his partner that he went there with, another guy named Gary Brodigan. Gary had been there filming, documenting the protest. Part of what Adam was doing was he was carrying a backpack that had extra camera lenses, some extra memory cards, just sort of helping his friend Gary just watch, just document, film, see what's going on. And again, not something that anybody argued over, certainly not at the district court, was not engaged in any kind of criminal activity, was not, being violent, was not sort of an active protester himself, just an observer, right? So Kopp says also that, he had no idea that, the crowd had become violent itself, that it had ever been told that it needed to disperse, that it had been declared in an unlawful assembly, or that there was some sort of riotous activity going on. Just there watching. So back to Deputy Palmer. So he's armed with his trusty pepperball gun, and what we know is that he fired first at least 2 pepperball shots. The first one hit the ground, and the second one hit another protester, who at that point then takes off, just leaves.
So it sounds like pepper balls are kind of half like tear gas, but like very focused, but also half kind of like rubber bullets.
I think that's right.
Both of those purposes.
I think that's right. Yeah, it somehow is supposed to sort of fit that seam where it's not this overwhelming chemical irritant that's going to go everywhere. In from what I could tell from how the district court had described it, that really they have a much more limited range. So it's about 8 to 12 feet is sort of like the area that an exploded pepper ball would affect. It wouldn't seep through the entire crowd, but maybe just for more sort of specific areas, right? And probably a bit, I think in theory, a bit more accurate than just firing off a tear gas canister into the midst of people where you can't really see who might be there, who you're aiming at, or who might be affected, whether there's like a small child. I think that's the theory, right? Yeah. So Deputy Palmer has first fired. He hit another protester. This protester left, and then fires towards this is where we get a little bit of disagreement starting to come in, but fires in the direction of Adam Kopp. And we know that Adam gets hit in the eye with something. So Deputy Palmer obviously says, well, if he did get hit, right, it must have been from some debris that kicked up off the street, or maybe it was from some particulate or some fragment of the exploded pepperball that I had fired. I wasn't aiming at him. I was aiming at the street. Unfortunately, something snuck up and got in Adam's eye. Adam, of course, says quite the opposite, in that he was aiming for me. He was aiming for my head. He hit me directly in the eye, and Adam's eye doctor actually submitted some testimony that does support this idea that he was hit directly in the eye with a full, intact, unexploded pepperball. Adam sadly lost his entire vision in that eye, so he's all vision use is gone, and his doctor had said that really, in order for that to happen, you would need to be hit sort of with a sort of significant blunt force trauma directly, to the globe, to the eyeball itself. So, in theory, some debris kicking up or some shrapnel fragment from the exploded pepperball probably wouldn't do it. But again, this is very much disputed, as to exactly what happened. In any event, Deputy Palmer and other officers see Adam at this point sort of fall to the ground, and the officers then approach Adam, right? And Adam Kopp and the officers agree. They saw that he had been hit. He fell. They went to approach him. They also agree that Adam was then taken back behind this police skirmish line. That Deputy Strickler helped him sort of rinse his eye out with a water bottle to get the pepper irritant out, and that Adam was sort of compliant at this point. While he sat with officers as they tried to rinse his eye out and waited for an emergency rescue medical squad to arrive and provide further treatment. They basically disagree about everything else. So the officers say, when we took him back behind the police line, Adam was, he was very agreeable. He was willing to go and get treatment. We only took him back there because it didn't seem like it was very safe, out where all this other, increasingly violent protest was going on. And we just wanted to make sure that he was going to be okay. And he went entirely voluntarily, no argument. Adam's part is quite different, as one might imagine. So he says, that when the officers approached, they immediately put their hands on him. They didn't let him go until he was back behind police lines. To him, the force and placement of the officer's hands on his body, he says, felt, quote, like control measures. And that he, and again, quoting from Adam, says that he did not believe he was free to go. And so it's also, and this is also part of what Adam says, is that it was only after he was taken back forcibly behind police lines, then he learned he wasn't actually under arrest. Okay, so we have sort of our factual setup, and here we are. He's been hit in the eye. He's been taken in some form or another back behind police lines. And without getting too deep into the weeds of some of the procedural back and forth to get us, into the district court and then up to the Eighth Circuit, basically what happens is Adam sues under Section 1983, and he brings a First Amendment retaliation claim, and then Fourth Amendment claims for unreasonable seizures, under two theories, right? So the first being that he was unreasonably seized with excessive force by being shot in the eye with a pepper ball. Sounds fair. And then that he was unreasonably seized by being forcibly dragged and removed back behind police lines. And just sort of a mini refresher, and as Tahmineh mentioned just earlier, so the officers at the district court, Deputy Palmer in particular, moved for summary judgment on qualified immunity grounds as to both the First Amendment retaliation claim and the Fourth Amendment claims. And for Adam then to defeat this qualified immunity, he'd have to show two things, right? That Palmer had violated his constitutional rights, Those rights were clearly established at the time of the violation. Now, what may come as a surprise to perhaps nobody around here, the district court went ahead and granted qualified immunity as to both the First Amendment and Fourth Amendment claims, and Adam appealed up to the Eighth Circuit. So Adam's initial First Amendment theory was basically that Deputy Palmer had violated his First Amendment rights 5 times over. So his initial complaint, he had sort of 5 First Amendment violation theories.
That's creative,
if you will. It was creative,
yeah.
And it was probably wise, right? And they may have all been true. Who knows? But he alleged that there was an unconstitutional retaliation for his protective expressive conduct at the protest. 2, that there was an unconstitutional violation of his right to peaceably assemble. That there was an unconstitutional restriction on a traditional public forum. That an unconstitutional viewpoint and content-based restriction in firing this pepperball at him and making him stop, saying what he was saying or being where he was. And then finally, a violation of his right to record matters of public interest. Now, I will mention that Adam failed to address the second, third, and fourth bases, the First Amendment theories that he alleged in his brief in opposition to to Deputy Palmer's motion for summary judgment. So the Eighth Circuit doesn't get there, but really only looks at his First Amendment claim through that first and fifth lens. And as I said, the district court went ahead and granted qualified immunity, and the Eighth Circuit, spoiler alert, agreed all around. Essentially, with the First Amendment claim, the Eighth Circuit agreed with the district court's reasoning that, Adam was just there observing, right? He himself had admitted that he wasn't actually protesting. He wasn't himself filming. He wasn't himself actively participating in the assembly. He was really just there sort of watching and holding extra camera equipment, but he wasn't there filming himself.
And he didn't allege that he's a member of a journalist organization of some kind, or this is something he does regularly. He was just kind of there.
Yeah, that's exactly right.
What the court thinks.
That's exactly right. Yeah, and it doesn't seem like he was actually able to allege that below, insofar as it likely would not have been accurate. But he certainly wasn't a member of the press. He didn't have a live blog or something like that he was regularly uploading his recordings and filming and documentation of protesting. Now, it did seem like his friend Gary was involved in that, right? So that might have been a little bit of a different case. But for Adam, he was just there as sort of a helper at best, carrying some extra equipment and otherwise just watching, but not really engaged in, in filming or documentation on his own. So the district court and the Eighth Circuit agree that there was likely really no First Amendment conduct, no protected expression that Adam was actually engaged in. And in any event, the Eighth Circuit says that in order to prove a First Amendment retaliation claim, you actually need to show 3 elements, right? You need to show, first, that you were engaged in your protected expression. Second, that an officer or government official took some adverse action against you that would chill, the words that we use are chill a person of ordinary firmness from continuing that protected expressive action. And then finally, that there was a but-for causal connection, right, between the retaliatory animus of the officer or the government official and the claimed injury by the plaintiff. And what the Eighth Circuit effectively said is that even if you had the first 2, even if you could show that you were actually engaged in protected expression, which we don't think you are, and even if we could show that the officer's adverse action would chill a person, which they don't speak to, but maybe. But either way, even if you could show those 2 things, you fail on sort of the third element for a retaliation claim, because you can't show that there was a but-for causal connection between Deputy Palmer's firing the pepper ball at you and your protected expression.
I mean, it seems
right?
like he thought he was a dude he wanted out of the way.
Yeah.
He didn't really care what he was doing.
Yeah, I think that's right. And I'll say it's not funny, but it's odd. Anyways, the Eighth Circuit does mention, as sort of part of its reasoning here, part of its rationale, that the officer, the Deputy Palmer, had shot someone else. So, in part, because Deputy Palmer had also shot another individual, it couldn't be the case that he shot you
Content neutral.
Out of retaliatory animus. Exactly, right? Because I've treated other people this same way, so it can't be that I singled you out for your protected expression. I'm just shooting, which is I found to be an odd line, an odd tact to take, but nonetheless, here we are.
You think that's going to hurt him with the excessive force claim, though?
You might. There's another problem here, and let's go ahead and jump to that now, right? So, we're unfortunately not going to succeed on our First Amendment retaliation claim, primarily because there is no, there's likely no protected expression. There's no retaliatory animus that we can identify, so you don't actually have a First Amendment violation to begin with. Setting aside whether or not it would have been clearly established, doesn't matter. We don't think you have a violation. But as you say, Adam also had 2 Fourth Amendment claims. So he argued that his Fourth Amendment rights, as I mentioned just earlier, were violated when Deputy Palmer used excessive force by shooting him in the face, in the eye, with a pepper ball, and when Palmer had unreasonably seized him by grabbing him and forcing him behind the police skirmish line. So, with respect to the first one, the Eighth Circuit noted that, and this is pretty common, right? This is sort of established that, whether a Fourth Amendment seizure occurred is a threshold question in order to establish an excessive force violation, right? So you actually have to know whether or not there was a seizure. Well and good. So the Eighth Circuit says that in order to be a seizure, the officer's conduct had to, and I'll quote a Supreme Court case called Torres v. Madrid, which the Eighth Circuit also cited, but the officer's conduct had to objectively manifest an intent to restrain, right? And again, this is a great side note, but Torres v. Madrid, if you haven't read it, please do. It's a very interesting factual setup, reaching this sort of Fourth Amendment question as to whether your seizure actually has to be successful. Your attempt to restrain must be successful in order to constitute a seizure. In any event, setting that aside, the Eighth Circuit agrees with the district court on 2 key points here. So the first is that there was no evidence that Palmer actually used the pepperball gun to apprehend in other words, like to effect a seizure, to stop him, or to arrest him. And then second, that bringing Adam behind the police skirmish line for medical attention was not clearly established as a seizure. So the Eighth Circuit here explains that there's actually a potential distinction between force that's used with an intent to apprehend and force that's used with an intent to disperse and repel. And this is sort of how we get out of seizure land. So the Eighth Circuit relied on actually a previous Eighth Circuit case called Dundon, I'm not actually sure how to pronounce it, v. Kirchmeier. And I'll mention this very quickly at the end as well. Basically, the court thinks that in deciphering an officer's purpose in using force, it's generally a seizure when the officer uses force in connection with apprehending someone or arresting someone or detaining someone. So the court looks at sort of the overall factual record to figure out whether Deputy Palmer used this pepperball gun in order to apprehend Adam or to disperse the crowd more generally. And agreeing with the district court, the Eighth Circuit, credits, as I think I mentioned earlier, credits Palmer's testimony that he'd only intended to strike the ground in front of Adam. Credits the fact that no one was arrested, that Palmer had shot someone else already, so he couldn't have been targeting him, and that Adam Cook was like 147 feet, almost 150 feet away, which is outside of the 100-foot guidance for using a pepperball gun for crowd dispersal, and therefore it's outside of the 30-foot guidance for specifically targeting somebody, and therefore it couldn't have been that he shot him for the purpose of apprehending him, because you only do that to people who were 30 feet or less away from you. That's the general rationale. So there's no seizure for the pepperball gun firing. And we can go ahead and say, because there's no seizure, no excessive force claim.
That is so nuts.
Yeah, it's a little bit nuts.
But yeah, I get. Well, Tahmineh, tell us how nuts you think it is.
Yeah, this is just really crazy, and there are just so many things going on here. And some background. I grew up in Iran, and one of my childhood memories. I mean, I wasn't a child at the time. I was like older. Early teenage memories was when the Green Revolution started happening in Iran in 2009. I don't know if you guys remember that, when Iran started seeing widespread protests across the country about the election results. And all these things were also happening. Like I saw these things like in front of my house, like cops coming in with armor and shotguns. God knew what was in there, tear gas and things to disperse the crowd. And then, but we found out that there are many instances where people were actually injured as a result of the methods that they used. And it's interesting that the court is in fact engaging with the mode that the officer used in this case. The fact that the weapon itself was like short range, so there's no way that it could have, been what the plaintiff was portraying it as. Like, there's no way that this could have hit him in the eye. Government's own policy says that you can only use this in this range, and how could it be how could it be anything beyond that? And that is just so judge-like to do, that when the government just shows any guidance or policy, whatever internal documents that they have on these things, the judge does not want to even imagine what if an officer goes beyond that? What if an officer breaks their even own internal guidelines, shooting someone where they shouldn't be shot? And I'm honestly a little disappointed that the court's analysis on this ended up being really circular. That, the guidance said you can only use it in this range, and there's no way this officer could have shot the plaintiff in the eye because the guidance says that.
It seems like the guidance, Ben, is this right? It's doing two things. One is to they maybe wouldn't have even done that because they break their policy, which of course people break policies all the time, so that's not very convincing. The other is that you wouldn't even try and get this guy at 147 feet because your gun wouldn't be very effective at it, and so he's obviously not trying to shoot him, which to me just means well, sure, but obviously this was negligent because it did. The facts are pretty strong that this pepper ball really did hit him, and so why can't it just be kind of a more like a negligence excessive force claim, or a ruling?
Right. And that might have been a possibility. There might have been a possibility to pursue a state law negligence claim, but that's not something that you could pursue, that he pursued here at the district court under Section 1983. And for that Fourth Amendment claim, for the excessive force Fourth Amendment claim, it's not enough just to be negligent. And part of the case law and the buildup of the case law is that you have to show that there was a seizure, which you couldn't show here. And part of that is sort of ties into something that Tahmineh was talking about earlier about courts consistently failing to reach that point, that sort of clearly established level. And interestingly, there is other case law that might have sort of supported, a theory that being shot with a pepper ball from that range would have constituted a seizure. But they never get there. There's a case out of the Ninth Circuit in 2012 it's 2012 is Nelson v. City of Davis, and the Ninth Circuit had actually looked at a case where officers had used pepperball guns to try to disperse a crowd of students at sort of an unruly, over-the-top party. And the Ninth Circuit had found that actually, even though you use this pepperball gun to disperse for purposes of dispersal, that in that case that the student had in fact been seized. And the Ninth Circuit says because the application of force there, it was actually like a knowing and a willful act that stopped the student's ability to move, that stopped a student's freedom of movement. And there are other cases like that. There's a Seventh Circuit case that came out in 2006 called Acevedo v. Canterbury. And here there was another police officer punching someone, but there was an officer that punched a guy in a tow truck parking lot. And the Seventh Circuit found that even though that man who was punched was able to get up and then walk away to his car, he had still been seized because he'd been temporarily immobilized, right? But again, and sort of going back to this clearly established point, when the Eighth Circuit looks back, and you mentioned some other, previous protests, but there had been, even in the Eighth Circuit, a case in 2021, which was Karaishi versus St. Charles County, Missouri. Officers had fired tear gas into a crowd of reporters. Reporters were monitoring, I think this was Michael Brown protests. And again, they say like, well, you didn't know. It's not clearly established that would have been a seizure. We're not going to establish it now. They released another case in 2022, Martinez versus Sass, and a similar thing. There was an attorney who was trying to follow her client into an ICE detention facility, and an officer pushed her away from the door. She fell, broke her foot, had a concussion, and again, the court said, well, you were repelling. You weren't apprehending, trying to pull in. So even though she was pushed and immobilized, like the man was in the Seventh Circuit case, and having been punched in that parking lot, it wasn't clearly established that that was a seizure. We're also not going to establish it now. And so we have this pattern of being able to look back and say, all these things that very much could be seizures, that other circuits have suggested might be seizures, aren't clearly established in this circuit. Because they're not clearly established, you lose. We're also not going to clearly establish it now. So I think that this is, again, sort of a line of that big problem of not being able to build up that body of law that says, like, okay, even if we're going to say that you get qualified immunity here, in this instance, moving forward, by the way, this is now clearly established as a constitutional violation, or at minimum as a seizure that could be a predicate for bringing an excessive force claim somewhere down the road.
Well, we'll keep looking for that clearly established law, even if we couldn't find it in this case. One thing I want to leave our listeners with after these wonderful presentations from my colleagues, who I thank for coming on, is was the law clearly established that Joan of Arc was not properly tried and burned at the stake? At least if you follow the French version. So maybe that's something that people can think about and write in if you got a clever answer for that. But until next time, I'd like to thank my colleagues again for coming on and wish you all a happy 2026. And please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.